So the question today is, what is the difference between a will and a trust? This is a very good question. It's one I've been asked many times. What is the difference between a will and a trust? They are very different documents. We're going to go through that today. One of the most common questions people ask when they begin estate planning is whether they need a will or a trust. Understanding the difference between these two tools is an important step in creating the right estate plan for you. You see, in estate planning, we don't want to create a right plan for me or somebody else. We want to create the right plan for you. So that means that we need to understand your situation. Okay, let's start with a will. A will is a legal document that allows you to specify how your property should be distributed after you pass away or after you die. The legal requirements for a valid will in the state of Utah are located in Utah Code 75-2-502. And under this statute, a will generally must be in writing, signed by the person creating it. It must be witnessed by two individuals who are not related. They are disinterested parties who are adults. There's other requirements as well. Look, a will allows you to name heirs or beneficiaries, appoint a personal representative, also called an executor or an executrix, but we call them personal representatives in the state of Utah, and nominate guardians for minor children. That's primarily what it's for, right? Who's going to get your stuff? Who's going to take care of your kids if they're minors? And who's going to be in charge? Who's the person in charge? That's really the guts of it, right? So how does a will not avoid probate? Well, believe it or not, a will does not avoid probate. A will requires probate. So when someone dies with a will, that will is submitted to probate court. So a will does not stop probate. Probate process is governed in Utah under Utah Code, Title 75, Chapter 3. You can look that up on your own free time if you'd like. Maybe I'll do a series later that goes through the probate code in detail. Look, during probate, the court oversees the administration of the estate and ensures that the property is distributed according to the will. Trust works completely differently. A revocable living trust, that's the most common type of trust we deal with when we do estate planning. It's called a revocable living trust. This trust allows you to transfer ownership of your assets to the trust while you're alive. Because the trust now owns these assets, those assets can pass to beneficiaries without going through probate. So one of the main ideas of a trust is you don't have to go through court. You keep things private. The court makes things public because everything you file in court is public record. You probably don't want your financial information, the important documents, that type of stuff being disclosed in court. So because the trust owns the assets, they pass to beneficiaries outside of court. And this can provide several advantages, right? One is it's typically more private than probate. Assets can be transferred efficiently. There's usually not a lawsuit involved. You don't have to get a judge's permission if it's a formal probate. And the trust can provide ongoing management of assets if you become incapacitated. Trust can also provide more control over how and when assets are distributed to beneficiaries. For example, parents may structure inheritance for children over time rather than providing a lump sum. Just FYI, fun fact is most inheritance is spent within 9 months of receiving it, regardless of the amount. So if you're going to inherit money, whatever the amount, if you're going to leave your kids $1 million, whatever it is, they will blow it in 9 months. So typically we put in some type of provisions to prevent them from blowing through it unless your kids are different and they won't do that. So something to think about. Many Utah homeowners and families with multiple assets, they want to do trusts. They want to plan their estates using trust. But remember, every situation is different. Not everyone needs a trust. If you don't have any children, if you don't have any assets, you may not need a trust. If you have no house, no estate to transfer, why do a trust? You probably don't need to. So every state's different. We look at everything uniquely and individually. Smaller states, like we said, simple family structures, they don't need a trust. They can use a will. Will-based plan is just fine. So the best approach depends on your circumstances. If you'd like help determining whether a trust is right for you or if you need more advanced planning, you can definitely give me a call. I'm attorney Jeremy Eveland, 801-613-1472. You could also click on the link below, go through a questionnaire and application, see if we are a right fit for each other. I hope you found this video helpful. Thanks for watching.